Until date where Nigeria returned back to democratic rule, there has been upheavals about insecurity. We've had challenges of terrorist groups, banditry, different shades, which really brought us to a point where we have to really look at the issues concerning insecurity and how to tackle it. Various state governments have made efforts to do this, and at the point we had the southern governors that converged on Asaba to look at this issue about having a state police and looking at the need to empower their security outfits in the region to tackle this whole madness and menace of insecurity in the region. Discussing the topic, which is on law and you, that borders on state security outfits and arms bearing, I have a custodian of the law. By that I mean a legal practitioner, Emmanuel Obakbolo.
Good afternoon, viewers, and good afternoon, Mr. Philip.
Let's look at the issue concerning creating security outfit in the state. Do governors have the powers to do so? And if they have the powers, do they have the wherewithal or the powers to give those security outfits sophisticated arms?
Mr. Philip, looking at the predicament we find ourselves today in Nigeria, since 2003, upon the new political era we found ourselves since 1999, there has been this hula baloo outcry for a state police. But the Constitution of the Federal Republic of Nigeria just now does not envisage the creation of state police. And by so doing, the security situation gets worsened. And state governors, by virtue of the provisions of Section 14, subsection 2A, that provides for the welfare and security of the people, the state governors now deem it fit, and not just fit, but also proper, to secure the lives and property of the people within their jurisdiction or units called states. And being that there is no room for state police, then the governors thought it wise that there is need for the creation of paramilitary group, which today that has metamorphosed into what we have in the western part of Nigeria called Amotekun, in the eastern part, Ebubeagu, and the various states in other parts of the southern states of Nigeria and the northern states of Nigeria have come up with their own, just like we have in Katsina State just now. And now the issue of arms bearing is now a double jeopardy, not just for the governor, but also for the people, to the extent of securing lives and property. Because the Constitution has what is called the exclusive list, the concurrent list, and the residual list. And by so provide the exclusive list, arms bearing is within the exclusive jurisdiction of the executive at the center. Section 3 of the Firearms Act provides thus that the President of the Federal Republic of Nigeria can grant license to any person or persons to bear arms. And even these arms are being categorized. Section 3 of the Robbery and Firearms Special Provisions Act provides thus that any person that possesses any arm that is not being licensed by the President or the Inspector General of Police via the Commissioner of Police of the various states shall be guilty of arms bearing offense and is so liable to imprisonment of not less than 10 years.
Or payments of fine?
Of 25,000 naira.
Okay.
Now, looking at these provisions of the law, you now see that it is within the exclusive power of the president, who can, by delegation, grant such powers to the Inspector General of Police to grant license to bear arms. And like I did say in my introduction, these arms are being categorized, except for Lagos State, where Section 5, subsection 3 of the Robbery and Firearms Act, Special Provisions, Robbery and Firearms Special Provisions Act, provide that the Commissioner of Police of the state can, by the consent of the Governor of Lagos State, grant certain arms, but not muzzle loading arms.
What makes Lagos State in particular different?
That is good. Lagos State before now is the federal capital of Nigeria. And as such, the seat of power was in Lagos, as at when this act was created. So it was like a special consideration because of the presence of the seat of power in Lagos State. However, they still enjoy that special provision.
But to an extent, in terms of sophisticated
yes, weapons. Because it depends on the category of weapons. Now, Section 3 of the Firearms Act provides for the kind of weapons that even the president can grant license to. Weapons like pump action, weapons like hunting gun, weapons like shotgun. Outside these three categories, no any other weapon shall be granted.
When you say hunting gun, what about the English double barrel? Is that not a hunting gun?
The English double barrel was captured not to be a hunting gun, particularly with the special one that is in existence just now. But the mere common English double barrel is falls within this ambit too, because it is also seen in the category of the pump action. Being it as it may, the creation of different security outfits or units by state governors in connection to Section 14, subsection 2A, B, and C is now a question for another day, or a question for legality. And that is why, upon the creation of these security outfits, the governors are finding it difficult to grant license to the outfits to have sophisticated weapons. And by so doing, some of them have made applications, specifically Benue State have made applications to the Inspector General of Police so that their outfits can bear arms, sophisticated arms.
Okay.
But that consent has not been granted for reasons best known, because to those who are to grant the consent, perhaps, to my mind, is because they don't want a situation where there could be clash between or amongst the security outfits we have today in Nigeria. However, it could also be for the protection of some special breed of persons in Nigeria.
Okay, we have state governments, we have a federating unit, states, the federal government, Can we say that the state being having a legislature like the State House of Assembly, that can also pass laws, doesn't the state enjoy that legality, to use the State Houses of Assembly, to make laws that could resemble that which will allow sophisticated weapons for the security outfits?
Going by the provisions of the Constitution and the Firearms Acts, and the Firearms and the Robbery and Firearms Special Provisions Acts, the state governors can only to an extent, whom the State House of Assemblies, make laws with respect to certain arms.
Not sophisticated
arms. And that is why you see today, the commissioners of police of various states can grant license to arms like hunting guns, can grant license to pump action, can grant license to shotguns, but they cannot grant license to long guns. They cannot grant license to AK-47. They cannot grant license to AK-49. It is within the exclusive power of the federal government. So here we are. And I think that with the special situation we have, special quote and unquote situation we have in our hands, the National Assembly, whom the various states House of Assembly ought to have come up with laws wherein the National Assembly will capture it in the Constitution so that the states can also grant license.
You are talking about constitutional amendment.
Yes.
Because basically we have the Constitution as the ground norm, fundamental law of the land. And National Assembly, whatever laws they make, is subject to the ground norm. And so it's only during the amendment process, which is also subject to the assent of the president.
Yes.
So that brings us to a point where if the president is not allowing this to fly, it means it can never fly, because you just said it, that all rests upon the president to do that. Now, as a region, we have a federal system of government, and some have always said that, well, how defined is this system of government that we run as a country, Nigeria? Otherwise, a federal system of government, doesn't it give the region, for instance, at the point where the governors of the southern states decided to converge on Asaba Delta State to discuss this issue about giving security outfits arms, into tackling herders and farmers clashes and all of that has to do with insecurity. Don't they, as a region, have the power? Or where lies the strength of the governor of Ondo State, who is also an SAN, Akeredolu Rotimi, that said that he has vowed to ensure that the Amotekun Corps have sophisticated weapons? Because he said so, that he has vowed, and he is constitutionally need to protect the state and its people. So looking at that, doesn't the region have powers or whatsoever? Is there any law in the Constitution that could give a soft landing for regions to so decide and legislate?
That's why I started by saying the present situation we have in our hand, the Constitution does not envisage it. And with these plights, the National Assembly ought to have made some considerations, even after the considerations have been made, where the president so withholds his assent. The National Assembly, both the House of Representatives and the Senate, can come together after 30 days to void whatever the president can do, to veto it. That is the proper language.
But we know the politics that go in between.
To veto
the
it.
aspect of vetoing the bill.
Yes.
It goes along.
Yes, but that's why I did say
Nigeria, the history in our politics have not given us the wherewithal, to do that. We've hardly seen the National Assembly, breaking grounds in that regard.
Because we do have a rubber stamp National Assembly. And also, like I did say, because of special interests of some persons. If not, with the present situation we have now, I think even the call for state police is ripe, is due. The question, the germane question, is why are they not? Why are they withholding that? Because some persons want to control the federal police at the center and also control it in the various states. And by so doing, there will be special protection to a certain group of persons or persons, as the case is. So, when we see special situations, and Nigeria is towing the line of the presidential system of government or the federal system as being practiced by the United States of America. In the United States of America, they have what they call state police, they have the regional police, they even have municipal police.
So what constitution are we practicing?
Why is ours different? We only pick the wrong side and encapsulate in the constitution because certain persons want to control everything. And that is why we find ourselves in this mess that we are just now.
Okay, by that are you saying that the system of government we are practicing is not really a federal system of government?
It's not true federalism. We are practicing a partial federalism, and I stand to be corrected. Nigeria is not practicing true federalism.
Does such
and that is why
it's either you are practicing a unitary system or a federal system of government. Now, if you say partial, what do you mean?
this is a country where the federal might can turn woman to man and man to woman. It does happen in this country, and that is why where the law provides for vacuum, that vacuum ought to be closed, because the general principles of law is that law does not provide for vacuum. That is the general principle. Then, where there is vacuum with time, with the passage of events, then there should be a law that should provide for that vacuum, so that that vacuum can be closed, can be filled.
Nigeria has been on this journey to make sure that this whole issue is closed. We've had the National Confab of 2014 that later on was swept under the carpet. Now, at what point would you want this conversation to go in the process of constitutional amendment where all of this will be harmonized?
Mr. Philip, the problem we have in Nigeria with regards to constitutional amendment is the politicians of today and those of yesteryears always look at what they stand to benefit and not what the people stand to benefit. And that is why this constitution just now, to my mind, does not need any even amendment. Repeal outrightly. We have good documents like the COFAB you just talked about. Where is that document?
So if you say that the National Assembly, the legislators are not really ready in this drive,
they are not.
At what point can we say this conversation is going to culminate into such developments? Are you saying that it's impossible to get it in the near future?
I don't see it just now. I don't see it in the next 10 years. I don't see it in the next 20 years. I don't see it in the next 30 years.
Nigeria can't be engulfed by this insecurity that seems to be challenging every state and community. Now, how do you think the law can come in here in terms of tackling issues of insecurity, even though we have challenge of security outfits having the sophisticated weapons that they really need to tackle this?
The laws we have just now have their own defects, and they have created lacunas. So until those lacunas are considered and something is done to eradicate them, we will just be on a standstill as we are. Take, for instance, the issue of state police. Nigeria is ripe for state police. But if you look at it the other way around, advocates of the non-creation of state police have the excuse that if state police are created, that the various governors of the state will also use it as their own tool to oppress those they think are not in their good books. That is what the advocates are saying. And if you listen to them keenly, to an extent, they may be right. But if we are fair, sincere, there is fairness, there is justice, as we are all clamoring for, these excuses will not arise. So that's why, as it is just now, with the special and peculiar situation we find ourselves, we need to ensure that the needful are done. The needful is carried out. The needful ought to have taken preeminence. But today, we see a situation where misplaced priority is the order of the day. We leave the real thing, we begin to chase shadows, because somebody is benefiting from chasing shadows.
Thank you very much. Well, in case you're just joining us, it's Law and You, and we are looking at state security outfits and arms bearing. And I've been discussing with a legal practitioner in the person of Emmanuel Obakolo. Let's look at the consequences, like you raised just now, over creating state police, and some advocating that if such is created, it could be abused by the governors. Now, let's look at this in total, and also look at the overlapping functions that may be created as a result of the creation of such, to fight insecurity. We have the federal police, then security outfits being given arms or culminating into having state police. Don't you think the overlapping functions could bring us to a point where it will become dangerous or harmful to the civilian population?
I do not think so if things are properly done. In the United States of America, whose democracy we copy, when have we heard that things of such take place there? No. Because the system has a way of not just checkmating itself. The system also has a way of correcting itself. So, in a situation where you have powerful individuals who are more powerful than the system, then things of such, just like you have mentioned.
Take for instance the state police and the federal police. They appear in a particular spot where they are to bring calmness to, in terms of ensuring that they tackle such insecurity in such a region. Which is supposed to take preeminence? Shouldn't it be the federal police?
No. Issues like all of them, all of the security outfits should have their jurisdictions. Okay. They should have their functions. The laws that create them also create their functions, also create their jurisdiction. But yeah, we misplace things. For instance, they said somebody has committed a crime. And instead for the police to go, you see the military will be invited. The military cannot be invited because the main function of the military is to protect the territory of Nigeria.
Not internal security.
No, not internal security. In internal security, what ought to be done is to call the police first. It is when the challenge seems to overwhelm the police, then you cannot invite the military to come in. But yeah, it is the military first. Take for instance the case of 20th of October 2020, the Lekki Toll Gate saga. Innocent persons who were there, young minds who were there, you now invited the military, not even the police. So that it is in situations like that you have crisis.
Okay, as a wrap up, what do you see as the short-term goal for state governments in tackling insecurity just now, since we are having the challenge of the federal government not giving license to security outfits to bear sophisticated arms? I
see us going around the cycle. We will not make any headway until the proper things are done. And I think that is why, to my mind, I say that there are special persons who are specially protected. If not so, why is the federal government withholding the consent? If not so, and also, take for instance, the security networks we even have in the states. Does the state have sensors of persons who are members of the security network? That is another germane issue. So, by the time you comb all of this together, you begin to see reasons why even those who are withholding the consent are withholding it.
Most especially when we have issues concerning some cult groups even within the vigilante.
The groups. So, the problem is here and there. And that is why, Mr. Philip, the difference between here and there is T, and T is time. With time, we will know whether we are progressing or we are stagnant.
Thank you so much for taking our time to be part of this. Well, this is where we call it a wrap on today's edition of Law and You. We do this on the next one. Goodbye.